Muda. Under
My lord, I have objections. This cannot be put on record, my lord. In fact,
How is that relevant?
and we have withdrawn that also.
Sir,
if my learned
If the officer of Muda is placed under suspension due to this, you tell me.
I will. That
Otherwise,
is, please
large
give me.
scale corruption
Yes, my
in
lord,
Muda.
answer is yes. Please give me a
That has been
minute.
withdrawn also.
Before I am able to complete it, if my learned friend interferes, what shall I do?
You know what?
Kodi, sir.
We have withdrawn that also, my lord. That cannot be relied upon. A
No,
document.
they have withdrawn that suspension.
Doesn't
Please,
matter, my lord. I
a
am relying
document-
upon it. My lord, if my learned friend will bear with me for a minute, I may be wrong, but I am entitled to be heard.
I think
All right. Yes, sir.
for a copy.
My lord, please look at page
Suspension
number.
order, government then.
My lord, please look at page
Placing
number.
the-
I too.
Where is the copy given to the other
So,
side?
my lord, we've given a copy. We've given a copy yesterday, my lords. We
Copy
was served,
ಕೊಟ್ಟಿದ್ದೀರಾ?
copy was served last week.
Yes.
My lord, please see page number, internal page number
My lord,
3.
my one request.
Let me say what I want to say. Then my learned friend can
Let
say
him
what he
finish,
wants
sir.
to say.
I don't want him
I
to
may
say.
be-
That's the
That
point.
this
I may
problem
be
is
wrong.
VC and this problem. ನೀವು
I-
VC ಹೇಳ್ತಾ ಇರ್ತೀರಾ, ಇವ್ರು ಇಲ್ಲಿ ಹೇಳ್ತಾ ಇರ್ತಾರೆ. Yes.
ಇಲ್ಲ ನನಗೆ ಒಂದು ಅವಕಾಶ ಕೊಡಿ ಅಷ್ಟೇ. ಸರಿ
No,
ಹೇಳೋ
no, he says it's already withdrawn.
No, my lord, there's a fact which is stated. I want to point out to your lordships that I
The
am
fact
not
of the
on
error, my
suspension.
lord, which we have withdrawn. That's the point.
We have
My
objected.
lord, can I point it out?
Material on record. It has no bearing on the case. This cannot validate the government.
No, even otherwise, the submission of the Advocate General is it is withdrawn. If it,
Yes, but
where is the withdrawal order?
I'm pointing out a particular fact which has been stated in this order.
No, in an order that is withdrawn, what can
Doesn't matter.
Put up-
The suspension might have been withdrawn, but the facts are there. Kindly look at that fact. My lord, I may be wrong. Look at it, my lord. Please look at it.
Let me see, sir.
My lord, please turn to
The
page
lordship
number
may
3.
kindly go to page
My
12.
lord, 1 minute, my lord. My learned friend will kindly
Yes,
bear
sir.
with me.
That's why you should be here, sir. VC ಇದ್ರೆ ಇದೆ problem ಆಗುತ್ತೆ.
Supreme
Yes.
Court matter ಇರ್ಬೇಕು, my lord.
My lord, page number 3 ನೋಡಿ ಒಂದೇ ಒಂದು ನಿಮಿಷ.
Yes.
ಅಲ್ಲಿ ಬಾ ಅಂತ ಇದೆ.
ಹಾ.
ಅಷ್ಟೇ ನಾವು ಓದೋದು, ಇನ್ನೇನು ಓದಲ್ಲ.
ಏನ್ ಯಾರು ಕರೀತಾ ಇದ್ದಾರೆ?
ಇಲ್ಲ ಅಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ. ಅದು ಬಾ. ಇದು ಬಾ.
ಬಾ
ಬಾ ಅಷ್ಟೇ.
ಬಾ ಅಂದ್ಬಿಟ್ರೆ ಆಮೇಲೆ
50-50 ಅನುಪಾತಿಕ ನಿಯಮಗಳು ಅಂದರೆ ಕರ್ನಾಟಕ ಅರ್ಬನ್ ಡೆವಲಪ್ಮೆಂಟ್ ಅಥಾರಿಟಿ ಅಲಾಟ್ಮೆಂಟ್ ಆಫ್ ಸೈಟ್ಸ್ ಇನ್ ವ್ಯೂ ಆಫ್ ಕಾಂಪನ್ಸೇಷನ್ ಫಾರ್ ದ ಲ್ಯಾಂಡ್ ಅಕ್ವೈರ್ಡ್ ರೂಲ್ 2009 ನಿಯಮಗಳು ದಿನಾಂಕ 30/7/2001 ಜಾರಿಗೆ ಬಂದಿದ್ದು ನಿಯಮ 3 ರಲ್ಲಿ ನಿವೇಶನ ಹಂಚಿಕೆಯನ್ನು ಲಾಟರಿ ಮುಖಾಂತರ ಭೂಸ್ವಾಧೀನ ಪಡಿಸಿಕೊಂಡ ಬಡಾವಣೆಯಲ್ಲಿಯೇ ಮಾಡತಕ್ಕದ್ದು ಎಂಬ ಅವಕಾಶವಿದ್ದು ಹೊಸದಾಗಿ ಕೈಗೊಳ್ಳುವ ವಸತಿ ಯೋಜನೆಗಳಿಗೆ ಈ ನಿಯಮಗಳು ಭವಿಷ್ಯವರ್ತಿಯಾಗಿ ಅನ್ವಯಿಸುವುದರಿಂದ ಈಗಾಗಲೇ ಅಭಿವೃದ್ಧಿಪಡಿಸಿದ ಹಳೆ ಬಡಾವಣೆಗಳಿಗೆ 2909 ಜಾರಿಗೆ ಬಂದಿರುವ ಮೇಲ್ಕಂಡ 50-50 ಅನುಪಾತದ ನಿಯಮಗಳು ಅನ್ವಯವಾಗುವುದಿಲ್ಲವಾದ್ದರಿಂದ ಪ್ರಾಧಿಕಾರದಿಂದ ಬದಲಿ ನಿವೇಶನಗಳ ಮಂಜೂರಾತಿಗಾಗಿ 50-50 ಅನುಪಾತದಂತೆ ಕೈಗೊಂಡಿರುವ ಯಾವುದೇ ಕ್ರಮವು ನಿಯಮ ಬಾಹಿರವಾಗುತ್ತದೆ. That is the stand taken by the government that 50-50 allotment is subsequent. Now here in this case,
who has passed this order?
Government, my lord. It is passed by the government.
Not government, my lord.
In the name of it is passed in the name of the governor.
Your lordship may kindly.
Now, my lord, let me complete, sir, if you don't mind. Now, my lord, all these.
My lord, all this is. I mean,
sir.
it's already been withdrawn.
Let him
What's the
finish it.
Okay, let him.
You read the withdrawal order. He will read the order. Yes.
And has no relevance to the case, my lord.
ನಾನು ಮುಗಿಸೋದೇನೆ ಇಷ್ಟು.
ಸರ್ ಮುಗಿಸ್ಬಿಡಿ.
ಅಷ್ಟೇ ಇಷ್ಟು ಮುಗಿಸೇ ಬಿಡ್ತಾ ಇದ್ದೆ. My lord, the illegal allotments, not in favor of the petitioner's right, the allotments, my lord,
That is in general in Muda.
correct. No,
That is where a committee was constituted to go into the corruption in Muda. That is already told.
no, I am not on corruption in Muda, my lord. I am on the government stand with respect to the applicability of the 50-50 rules. The 50-50 allocation, even according to the government, I am on the content of this order, is post 2009. Here, my lord, all these sites were allotted in 2003. Therefore, the 50-50 would not apply for allotment in favor of the petitioner's wife. Because the illegal encroachment was in 2003.
Sir, that's by a separate notification. We'll consider that.
That's all that I'm saying, my lord. This
I
is,
think
this is a piece in the jigsaw puzzle.
Yes, sir.
Please, ma'am. Yes, ought to be, in fact, your lordship.
Where is the order of withdrawal, Kodi?
Your lordship may kindly see page number, my lord. Page number 12, my lord. In fact, my lord, what has happened pursuant to that, my lord, a representation was given by the said officer saying that these are factually incorrect statements have been made in the suspension order. That is at page 8, my lord. Pursuant to that representation, my lord, it was forwarded to the Department of Personnel, UD department. Then they sought for certain clarifications. Pursuant to that clarification, my lords, we have passed a fresh order of withdrawal of suspension that is dated, my lords, 3rd September 2024 at page 12. So, in fact, my lords, having produced this order, my lord, they ought to have produced the withdrawal order. They can't mislead, my lord.
The withdrawal order communicate ಮಾಡಿದ್ದಾರೆ.
No, we didn't communicate it to the suspension order also, my lords.
ಅಲ್ಲ ಆಫೀಸರ್
ಆಫೀಸರ್ ಯಾರಿಗೆ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡ್ಬೇಕು ಅವ್ರಿಗೆ ಮಾಡಿದ್ದೀವಿ. And it is between us and him.
ಅವರಿಗೆ ಪತ್ರ ಲಗತ್ತಿಸಿದೆ ಅಂತ ಏನ್ ಕೊಟ್ಟಿಲ್ವಾ?
ಏನಿಲ್ಲ.
Yes. All right. Yes, sir. Yes.
Lord,
Senior counsel has come. ಅವ್ರು ಮುಗಿಸ್ಬಿಡ್ಲಿ, ಏನ್ ಅರ್ಜೆಂಟ್ ಇದೆಯಾ? ಏನ್ ಹೇಳ್ಬೇಕಾಯ್ತು?
written synopsis filed.
ಯಾರ್ದು?
Respondent number 3. Lord, one aspect, my lord, the earlier case in second.
ಇನ್ನೊಂದು ಹಾಕಿದ್ದೀರಾ ಸಿನಾಪ್ಸಿಸ್?
Please,
ರಂಗನಾಥ್ ರೆಡ್ಡಿ ಅವರೇ,
please.
ಸಿಂಘ್ವಿ ಸರ್ ಆಮೇಲೆ ಪ್ರೊಫೆಸರ್ ಮುಗಿಸಿದ್ಮೇಲೆ ಮಾಡಿ.
Great. Because there are some issues, but they are hard to answer.
Only 2 minutes.
Please,
You should also sprint in 2 minutes.
please.
Yes, sir. Yes.
I thought it was.
No, it's finished. File ಕೊಡಿ ಮೇಡಮ್. ಮೇಡಮ್ ಮೇನ್ ಫೈಲ್ ಕೊಡಿ. So we're going to conclude this today, sir.
Yes.
Yes.
Wait, please, my lord.
Yes.
Whereas I am going to give your lordship say written submissions in the form of whereas extracts are also
Yes,
there.
sir.
Everything is in one place.
Yes.
And whereas I'm going to read some parts of it, but I'm going to whereas just develop the nuances of some principles of law. Your lordship may not find it in the sequence in which it is argued, but I'm going to be rejoining to each point,
Yes.
but in a different sequence.
Yes.
Your lordship may not whereas possibly get the answer to a particular question in the sequence your lordship expects it, but whereas I'll do it in that way.
Yes.
And I will whereas deal with all the issues raised. But let me whereas at the outset, before I hand it over, give your lordship a summary of what I want to sketch out, and then whereas continue in that line, in that sequence. Well, it's the first part is, of course, to keep in mind the backdrop of the umbrella of statutory protections provided, especially to an elected public servant, paving the way for an inquiry or investigation, which Balaz has very serious implications of Balaz diluting or unseating or creating Balaz a mandate contrary to the election. So that has to be interpreted in that contextual manner. That Balaz, it is not just a walk-in, walk-out system. There must be a proper protective umbrella which is given its proper full letter and spirit. Balaz, implementation is a general backdrop point. Now, Balaz, the other part which I will develop, I'm just giving a summary, is Balaz, that it is a mistake to suppose by just citing MP or 1 or 2 judgments that the moment any government minister or chief minister is involved, automatically this very well and old and long established jurisprudence about governors having extremely limited circumscribed powers to act in their discretion, so-called discretionary powers, is automatically overridden. So the Constitution says, and Shamsher Singh remains the bedrock, says that the discretionary so-called exceptional powers of the governor are so limited and so specific. You now read onto it a proviso which is not there anywhere in no case law, and it's a misreading of both Shamsher Singh and of MP to suggest that there is. You engraft upon it a proviso to say the moment automatically, and I repeat the word automatically, a chief minister is involved, you must assume that the advice of the council is biased and engraft the discretionary power. That is not what either Shamsher Singh, forget Shamsher, MP says. Does not. It's a much more nuanced law. The nuance is that the law remains the same. The governor has no discretion because it is not part of his list of discretionary power. Obviously, we are not dealing with the discretionary power. Those are different areas. So in the normal course, the governor has no power. However, if it is shown, and the word shown is important, that in a particular case of sanction, the order denying or recommending no sanction suffers from transparent apparent bias. That is to be demonstrated. And the second thing was completely forgotten in the respondents' arguments last in the manifest irrationality. So there is no auto. But I come as a slotting machine, I'm a chief minister, there is a cabinet, therefore auto. MP, you must straight away ignore, and the governor is free to act. No. The governor has to demonstrate that I am now acting in my discretionary powers because of A, this apparent shown bias. Shown means prima facie shown.
Yes.
And second, where there is no bias shown, and this is one case, and MP is very interesting, not a case of bias at all. The case went on, the demonstration that this order suggesting no sanction, words are, is manifestly irrational. Once you demonstrate that, then your discretionary powers come in, is the nuance point, much more nuanced than the generality of what was argued. That look, I have told you, this is a cabinet, this is a chief minister's case. No such concept. We state of apply. That I'll be demonstrating, Manus. The third aspect I'll be demonstrating is that your lordship has a very interesting order. According to this short point, which I'm now saying, is sufficient to set aside the order. I'm not saying your lordship will set aside on only one point. I'm just saying it is sufficient. It's so important. And it should be given its due importance. Well, it's without prejudice to what I'm saying about the nuance of Shamsher Singh and MP police establishment. Without prejudice to that, the entire 5-6 page order of the governor, impugned, is only on one point. I am deciding independently. I am not bound by you, the order. Entire, I repeat. So the most important part of this case, if your lordship were forced to single out the most important part, is that for a minute, if your lordship accepts that he is not bound, without me conceding at all, I am always very heavily opposing it, but that he is not bound. The governor has not gone beyond those 5 pages to add a word as to how, not being bound by these people, I find how, what, when, or where the CM is complicit, prima facie, and therefore I grant sanction. His role, that is the CM's role in this file, the CM's decision on that day, the CM's ministry on that portfolio, the CM's file noting on that particular event, nothing is to show prima facie complicity, but I grant sanction because I'm not bound. The Honorable Governor, therefore, commits a very serious constitutional sin of answering a very important constitutional question by the answer, why not? The Constitution asks him to say why, not why not. Your lordship knows what is the why not versus why.
Yes.
Why not grant? We'll see. Sorry, that's not the constitutional thing with this. You have to show affirmatively why your lordship should be. Your lordship doesn't decide matters by saying why not we allow or why not we dismiss the petition. Your lordship is forced to give reasons, Willis, as to why. So that's the test. On this short point, Willis, the impugned order is liable to be set aside because it does not address the question. It does not deal with it.
No,
Now, the fourth point.
One clarification.
Fourth
sir.
point.
You said that the governor has passed the order without arriving at a conclusion that the cabinet was biased, or without even observing. a
Without any
cabinet was-
material.
Without any material to
He
show
says
that.
it is, I'm sorry to interrupt, my lords. He does say, this part he addresses. The
Yes.
other part, he does say, the cabinet is ultimately the cabinet headed by CM, therefore it must be biased.
So, no, he presumes it to be biased.
I'm very
is what-
grateful.
is
Presume
what
is the
you
right
say.
word.
Presumes it to be biased. There's a concept of unconscious bias or subconscious bias.
Maybe.
Now, which cabinet will tell their leader to be proceeded against?
Well, it's-
Which cabinet will approve, saying that, yes, he is our chief minister, governor has sought opinion of the cabinet, and this cabinet is going to permit sanction or approval for proceedings or sanction for prosecution. Which cabinet will do that? Which cabinet will go against their leader?
No,
So this, if not apparent bias
yeah.
or rational apprehension of that bias may have led.
May
But
I-
that should be reasoned out, is what.
May I answer?
Yes.
So first part is not reasoned out.
Yes.
First part is that, but second part, your lordship query is more important. Well, then, if your lordship were to accept that as a principle, then it is a case of presumptive bias. Then your lordship is not doing, kindly see what your lordship is really doing. I'm answering my lord's query on an argumentative basis. My lord has put a very important
No, there was a
question.
clarification.
No, it's a very important question. But just see, suppose your lordship's formulation as a, only as a, well, as a question
only
to
a
me,
clarification.
only to
What-
elicit from me. Suppose your lordship's formulation was correct, just for a minute, just, obviously your lordship is not giving any, your lordship is only
That's true. sir.
discussing. Suppose the lordship formulation was correct. It would mean exactly what I said in the previous sentence.
Why not?
Presumptive assumed bias in every case. Well, tell me which case your lordship will have of a sanction where your lordship will not have to apply this principle. But the law, the constitutional law is not that. Because your lordship then has the moment, then what is your lordship doing? Then my lord has in the constitution, A, B, C, D are only 4 discretionary powers of the governor. My lord is making this a fifth category. Always. Always. Then, Malus, why does MP go on? MP, Malus, doesn't go on the bias. If presumptive bias was correct, it had to be finished. It goes by analyzing that the reasoning of the cabinet is not right. It is manifestly irrational. And it is not irrationality, manifestly irrational.
A little higher
high.
pedestal of
I'm very
irrationality.
grateful.
Like how it is arbitrariness and manifest arbiter.
So, Malas, I'm very grateful, in fact, for the clarificatory question. The only case chosen by the Honorable Governor to cite is MP. But I've analyzed MP very carefully now, Malas. I hate to say this, but possibly the Governor has not been assisted sufficiently, he's not a lawyer, to analyze it equally carefully. MP does not go on bias, which answers my Lord's query, because in every case of a cabinet and every case of a governor, then MP must be read to mean it's a 6th category of discretionary power of governor. MP doesn't say so. Secondly, if my Lord's the clarificatory question was correct in the conclusion, then there will be no manifest irrationality. Which governor needs to go to manifest irrationality, Wallace? Doesn't need to. Your lordship is not to waste your lordship's time to go to manifest irrationality when
No,
it's
not
a
necessarily.
presumptive bias.
It was only a
Presumptive-
clarification that.
No, I'm not saying your lordship, I'm answering your lordship's question. The governor doesn't have to waste his time. If he has, well, why should he examine manifest irrationality? So suppose, Balas, and there are 2 categories. One is, Balas, your lordship has given me the category where which cabinet will go against. Of course, Balas, in politics there are enough cabinets which go against you. It is not, Balas,
It is true.
so sanguine and so uniform as your lordship might think, Balas. These are very turbulent waters,
No,
to put it mildly.
yes, sir.
But that apart, your lordship is, Balas, not looking at the other aspect which my learned friends will, my learned friends are not looking at the other aspect which your lordship will appreciate. That, Balas, cabinet, if it gives, forget this case for a minute. I'm testing a lordship, the proposition. If the cabinet in a hypothetical case gives perfect reasons, right, it says this chief minister has done nothing.
That's what the
Yes.
cabinet noticed
No,
in the case.
I'm not saying my case. Forget
Yes.
my case.
All right, hypothetical.
Hypothetical case, that this cabinet has said that this chief minister is always sitting at a 10-mile distance from all these decisions over 20 years. But in fact, it's a very unusual case. I mean, I'm going to be delivering all this. It's a very, very interesting case, fellows. 23 years. Well, in 23 years, at least 23 public servants must have been involved in this. The list of dates the lordship has got from my side and this side.
Yes.
One person is singled out by these complainants, 3 complainants, with somewhat dubious antecedents sketched in my petition. One public servant is culled out after 20 years. And in those 20 years, this man has been a minister from his 1984, I think he became a minister in the 80s. Across, he's held many portfolios. No particular portfolio on this issue, no particular file, no particular decision, no particular recommendation, no particular approval. Your lordship will not easily find a case like that. Your lordship finds. Now I can understand the governor saying, despite this, I find Mr. Singhvi's reasoning wrong by 1, 2, 3. But more importantly, apart from Mr. Singhvi's reasoning being wrong, I find that Mr. Siddaramiah is complicit or is involved prima facie or needs to be given sanction prima facie because of ABC. He doesn't say it. He doesn't say it. He doesn't address the issue. Which brings me to the next point. And therefore, very important clarification. I'm very genuinely grateful for your lordship's query. 2 answers to that. 1, your lordship is not carving out a new category of presumptive bias. 2, MP, which is the only case relied upon for only by the other side, forget the other side, by the governor, is a case where they did not take up apparent bias in a cabinet governor case. And 3, it must show, therefore, a perverse 2 + 2 = 5 error amounting to manifest irrationality, which the governor has not said. He's not even said so. If he had said so, I would have shown he's wrong, but I don't need to show that because he has not said so. Now, which is why it brings me to my 3rd point. It is because of the previous point that my learned friends do something very extraordinary. That is, the state government. I'm sorry, the persons representing the governor, not the state government, the persons representing the governor. Of course, governor acts to the state government, but he's represented by a separate council. Very extraordinary thing. Keeping in view that there is nothing about manifest irrationality. There is nothing about any reason by the governor and nothing reflecting the process of ratiocination. A lot has put it very nicely in many judgments. These are the materials. That is the conclusion. The chain which links the material with the conclusion is known as the process of ratiocination, the process of reasoning. Now, there is no reasoning about why he is guilty, prima facie, or why the cabinet is wrong. The only reasoning is that the presumptive doctrine my lord put. Per se the cabinet, per se the chief minister, therefore I must act. Why I must act is not there. Which is why a 3rd point is pressed into service after the case starts. What is that 3rd point? Knowing that there is no manifest irrationality commented by the governor, knowing that he has not dealt with any issue about Mr. Siddaramiah, knowing that he has not found any reason to deal with the cabinet itself. They say now, after the case is started, we will not file an affidavit. We will produce files. And I mean that, like Alice, it gets more and more curious. So first thing is, I will produce files. Files are produced. Second thing is, in the files, there is only, if you lordship will look carefully, a chart saying 2 versions. Version 1, version 2. There will always be 2 versions, There is hardly a case which does not have 2 versions. Life is all about grey, very rarely black and white.
2 versions and the minimum.
Minimum, if not 3, 4. Absolutely correct.
Multiple versions.
Our religions say that it's multifaceted use. There is no relativity doctrine itself. Everything is relative. Time and space is also relative. What about versions? Versions will be many.
Minimum 2 versions.
Minimum. He then, Malas, puts the two versions, and in the entire bunch, big fat bunch given to your lordships, he doesn't say anything except at the end, I think it should be given. But more importantly, none of the reasoning in the files by the lower officers, not one word is reflected in the impugned order. There is no law that I know of that you produce material and say you deem this sanction order to be valid, because at the back of my office, people gave me 5, 10, 12 versions with 1,000 pages of files. That is like saying that I will be the inscrutable sphinx. Behind the inscrutable sphinx, the pharaohs put a lot of gold and a lot of
Yes.
saman inside.
The silence comes about.
So
only
I will
because of
remain
that.
the sphinx, but the saman behind in my grave can speak for Malas. It all lying in the
No,
things
that's
will
right. Inscrutable face of the Sphinx has something behind it which cannot be projected by that silence.
And your lordship as a judge should be deemed to validate the inscrutable face because of the saman behind it. But what is interestingly, that huge treasure house of saman is not finding a word of reflection in the order. Well, I can understand. Nobody is saying that the governor is a judge who's writing a 50-page judgment. Nobody is suggesting that. The governor could have given some reasoning culled out from those two versions and 1,000 pages. It is not for your lordships to rewrite the order of the governor. That I am the judge, you have thrown at me 1,000 pages, the order says nothing. I as the judge will ex post facto validate it by giving these reasons. Which ultimately comes back to the same point, Malas. The point remains the same. That your lordships is entitled to quash this order on the short ground that it is not dealing with these issues. Neither manifest irrationality nor why. You are saying, of course, that there are reasons inside. But Malas, and two versions is not a sufficient ground at all. Much more so, Malas, when you are disagreeing. You are disagreeing.
Yes.
You are not upholding. Your lordship knows, Malas. There's a difference. Your lordship judicial review is much more heightened when the primary matter is coming on a disagreement. Your judicial review is a little different when it's coming on an affirmation. So that was the third and fourth point, Malas, which I'll be developing. The other point is, Malas, about 17A. Now, Malas, there are two facets there I wanted to just touch on, then I'll be developing them later. Malas, 17A is not, Malas, in any manner, 2 or 3 points. First, in 17A, the interpretation canvas for your lordship is to an extent, Malas, faulty and erroneous, is my submission by the other side. Why is that? A very broad brush blanket proposition is thrown at your lordships. Lalita Kumari test is 17A. I strongly object to that. Lalita Kumari test is not 17A test. In fact, it's very interesting. I've now investigated the legislative history of 17A. The idea of 17A was to provide a genuine, strong filter.
Yes, a protective layer.
Protective layer is the correct word, filter is the correct word, and umbrella of protection is the correct word.
No, both are used to protective layer to protect the innocent and not shield
Not
the
shield the
guilty.
guilty. Correct.
That is what
Malas,
is said
correct.
in that.
Absolutely. But Malas, Lalita Kumari, born much later, can't be just Malas read into 17A.
No,
These
when
tests are all mixed up.
17A comes into the statute,
Yes.
Lalita Kumari is 4 years before the 17A coming into the statute.
No, that's true, Malas. But the FIR test of Lalita Kumari could have easily been put in 17A.
Oh, that is not put anyway.
No, not only that. I show that, but in fact, the legislative history originally of 17A provided for the filter through the Lokayukt. That's very interesting. The idea was that I am now, Malas, not on the deletion because the first argument will be deleted, which means the filter is, that's not the argument. But what happened was that they went through very draft. I've got in my note, Malas. Broadly, it said it is a protective, they were emphasizing the protection. Otherwise, governance will come to a standstill. That's the whole idea of this, Malas. We have enough people, Malas, taking pot shots every time. And according to me, this is a classic case because after 20 years, your lordship has different kinds of. But the protective layer originally envisaged was A, a full substantive, and B, it had to go to a very detailed scrutiny, and they put the Lokayukt. Then they said Lokayukt will be a different institution. So we change it only as to the hooper, not the test. We change it to the government or the police officer. So Malas, the change is from him to me. The change is not of the degree or the heightened degree of scrutiny required. That's going to be my point. Then, Malus, to dissolve it from that higher test into a Lalita Kumari test. Lalita Kumari test is a very, you should know what Lalita Kumari test is, Malus. At the end of the day, it is ultimately, Malus, you go and file something and you're supposed to act on that. That is, Malus, reducing the entire object of 17A. And then, Malus, I'm also going to be showing to your lordships that, and this, your lordship has a judgment on this, Malus, Shirupas, but I have a Malus different nuance to it. I've quoted it as to the nuance. Malus, I believe, and this is going to be one of the arguments, Malus, that it is for the investigating officer to first form an opinion that inquiry or investigation is warranted. I'm choosing my words carefully. The investigating officer must first form an opinion that inquiry or investigation is warranted. I am the investigating officer, I form the opinion about him, and then I seek approval for that opinion, having that first form the opinion. According to me, Malus, to allow a outsider, a third, not out, let me go to third party.
Who is the third party here?
Third party,
The
Malus,
complainant?
complainant.
All right.
The third party could be, I mean, outsider or complainant or whatever, Malus, third element. Or a stranger, to come into it is to actually remove a very significant part of that protective layer. Because I am the investigating officer, I form an opinion about it. I take it elsewhere for approval. Thereafter, people, it's not that it's the end of it. There are so many other remedies. But here, my formation of opinion is the first step. Approval is the second step. Before these two steps, the third party actually removes the protective layer altogether. That's the second error on 17A, is going to be my submission. And Shirupa is being wrongly read. The Lordship has not changed this law, according to me. And Malus, of course, other issues will be there, which I will be coming to later. So let me, and of course, on the facts, I'm saying. On the facts, that's a separate argument, Malus. On the facts, if your lordships, and this is wholly without prejudice, applies even Lalita Kumari. You don't even satisfy Lalita Kumari. You don't satisfy Lalita Kumari. Because, Malus, same question. On Lalita Kumari, you have to show some complicity, some involvement, some what, where, how, when.
That's para 120.1.
It comes to that, Malus, ultimately. I am trying to assist both on the legal principle and then, of course, the facts. Now, let us just, this is a fairly long preface. Let me start with the note. Give the copies to the other side.
So this was a preface.
No, it's a summary, not a preface, a summary. Just tell us. No. Now, Malis, I'll be reading parts of it, but and then let me read the first part of it.
Yes.
At the very outset, it is most respectfully submitted the present case falls for this Honorable Court's consideration of an action taken by the highest constitutional functionary of the state, by which the umbrella of statutory protection accorded and afforded to public servants has been lifted. Case involving the elected chief minister, paving the way for an inquiry or investigation. As such, shorn of the personalities involved and the positions which they may presently hold, this Honorable Court must subject such action. That's the point I'm trying to make. It's your lordship's scrutiny.
Where are you reading?
Oh, I'm very sorry.
Yes.
I'm very sorry. Para 1.
Oh,
My apologies. I thought your lordship.
yes, sir.
And it will be faster reading many parts of it because of quotations,
No
but there are
problem.
very important
Yes.
points. The nuances are important. That's the.
Yes.
So now the first para is not about chief minister. It's about the heightened scrutiny of the court required. That's what I'm on. At the very outset, most respectfully submitted that the present case calls for the Honorable Court's consideration of an action taken by the highest constitutional function of the state, by which the umbrella of statutory protection accorded and afforded to public servants has been lifted. In a case involving the elected chief minister of the state, paving the way for an inquiry or investigation, as such shorn of personalities involved and the positions which they may presently hold today, this court must subject such action. This is the proposition. This court must subject such action to the necessary judicial scrutiny, such that the fine threads of constitutional democracy are kept in balance, are not frayed by unduly stretched or torn asunder. Little rhetorical, but this is just a setting. Little rhetorical. I'm not otherwise trying to. The following points are highlighted.
Torn apart. Yes. Asunder is apart. Yes.
Correct, absolutely. The order of granting approval must fully disclose a reasoned application of mind by the authority concerned. In the instant case, the impugned order of the governor fails to meet this test. The fact there exists this power, albeit an extremely narrow one. Now, this is the nuance. It exists. Nobody is denying. My learned friends have argued as if it's an automatic. You just call out two names: cabinet, governor, chief minister. New discretionary power. No. Narrow one, to differ with the aid and advice in certain situations, I will be demonstrating this, does not exempt or relieve the governor from the obligation of passing a reasoned order disclosing application of mind. Because they are doing a double whammy. Just note this. Actually, in the normal course, the governor is a no-go area. You are allowing a special area to the governor in a matter where also additionally having taken that power, he's not disclosing his mind. I will call it, Malos, in loose colloquialism, double whammy. The governor anyway can't enter this house. In the case of a chief minister, a nuanced, limited case, he may enter the house. But having entered the house in an exceptional area, he also gives no reasons. It's a double whammy. It's a double constitutional whammy. The reliance by respondent to on file notings and comparative charts, tables or notes analysis as dictated by the governor. Well, I take it when we say dictated by the governor, no governor dictates what your lordship saw. We all accept it. We can say dictated by governor's office, no problem. Don't say dictated by the governor. I don't think anybody here is so gullible to think the governor has the time or what is the interest to dictate what your lordship saw in the files. So let's call it governor's office. Is wholly impermissible. We live in the real world, Manoj. We have to smell the coffee. We can't be in some other land, Manoj. Is wholly impermissible in the absence of these documents being placed on record under cover of an affidavit. That also I let go. Manoj. The affidavit is not put. Let's leave that. It's a point to be noted nevertheless. Moreover, in any event, the impugned order itself refers only to allegations in the petitions and the supporting documents and makes no reference to these charts, tables, notes, analysis in the order. No reference, Manoj. Not one word. Not a word. I've checked it, Manoj. And therefore, it is not an order which refers to or is based on antecedent file notings, nor does it endorse, accept, adopt, or in any way engraft such notings. All those 4 words. Endorse, accept, adopt, or engraft. Manoj, if this principle is accepted, which judicial review can your lordship squash? I am putting the same kind of question in different way. Which lordship will never have a case. The file speaks for itself. I have written an order, matter dismissed. Please check up the file and find the reasons. I have a very impressive staff. I have thousands of pages. I have people making notes. I have dismissed your matter. Check up the reasons from the file. That's not the law, Malas. The whole administrative law, public law will fall to the ground. Your lordship's doctor of judicial review, forget Tata Cellular, Malas. Ordinary principles of judicial review will not be there. The nature and extent of judicial review as it applies to such actions of the governor, applying his independent discretion. Now, Malas, here you are more. Your lordship knows you are going to exceptional area. Therefore, judicial review is more. Therefore, reasoning has to be more robust. The other nuances which have been missed out, with great respect, I say so, in the respondent's approach, must be all the more robust in cases where the governor is exercising a power that ought ordinarily to be exercised only on the aid and advice of the Council of Ministers. Thus, in cases where a different view is taken, the burden is higher to show that there was manifest irrationality. This is a phrase of Wallace MP. In the advice of the Council of Ministers, thus requiring the matter to be considered decided independently.
So whenever the cabinet he is disagreeing with the cabinet, the reason should be on a higher pedestal.
A, starting point is that. B, your lordship's scrutiny also is correspondingly more heightened on those reasons.
Yes. we will.
It's not, nobody is final, only your lordship's final, that too on subject to Supreme Court.
Yes.
In fact, the Supreme Court joke is the Supreme Court is right because it is final. It is
That
not
is-
final because it is right. Nobody is final except God, Malas.
Yes.
But in our hierarchy, the governor is not final.
No, we are reviewing it now. Yes.
So, Malas, these two double heightened is important. Malas, you are going to an exceptional area. The Malas, very nice. Those debates are worth going every time back. When I read those debates, Malas, Mr. Ambedkar, there's a huge long debate about governors, Malas. He says, why should you not have elected governors? Very strong, genuine proposal, bona fide. Then there's another debate about, well, how will you find good people? So he says, Mr. Ambedkar replies, says, there cannot be two swords in one scabbard. Ek म्यान में दो तलवार नहीं.
That's why Article 143 of the debates was reduced to 163. to
163,
be
no, and then he
in
says
the
in the debate, he
Constitution.
says there can't be two swords in one scabbard. Then he says that we are in fact thinking, it's a very interesting passage, we are thinking of nominating governors, and the post is so kind of non-active that we are very doubtful that we'll get any applicants for the job. That's not true today, Manas. But Ambedkar certainly thought that, Manas. Anyway, the idea of a governor was a no-go area in 95%.
No, if
Now,
you see
if
the
you-
Constituent Assembly debates,
Yes,
where
yes.
it was, the draft
Yes.
was drawn first. Article 143 dealt with this. where
Yes.
Governor has to be elected, nominated or otherwise.
Exactly.
Then 163 is the final form that has come.
In between
That's-
is this discussion, he said, no, elected means he's also elected chief minister. I am also elected governor, two swords in one scabbard.
That's why it was
Want to
not.
neutralize him and put him only below the nominated. Then he says nominated also with very little powers. Nobody may want the job at all. Then what is the next point? The power of granting approval under 17A of the POCA is not an independent discretionary power of the governor, but an executive power or executive function which is ordinarily and normally be exercised by the governor only on the aid and advice. This is consistent with both some last sentence in my proposition, wrongly suggested to your lordships otherwise. A broad brush is done. It is thrown, some share had this, on that one word, not exhaustive. Lordship remembers the argument, it's totally wrong. Exhaustive doesn't mean Lordship is rewriting the constitution with a number of new engraftment of the governor's power. The exceptions to this rule are not an open-ended category, nor did the Honorable Supreme Court in some shades to set forth a non-exhaustive list as sought to be contended. Now, real para is, this is IR 154. And there is nothing in the majority which is inconsistent with 154. Nothing. As part of the concurring judgment, there is no variance by the majority to this concurrence. I'll be developing all this, but it's just a summary. The decision is MP Oil carves out a narrow MP Special Police, I'm very sorry, narrow and extremely limited exception where the governor may differ from the aid and advice. Now just see the nuance. Where there is overwhelming material on record on the basis of which prima facie case is clearly made out, and yet the council has refused sanction. I'm taking Wallace. Forget this case, I'm giving the law Wallace. Then to the extent the decision of the council is ex facie or manifestly irrational. Manifestly means ex facie actually. Or relevant material has not been considered, the governor may take a different view. That's the nuance. The findings in para 32 of the judgment, which are cited in the impugned order, relate to manifest irrationality and not to apparent bias. Now look at the error now. This is a matter of caution. I don't want to oversimplify, I don't want to exaggerate. Just kindly consider this. The governor, the Honorable Governor cites one para of MP, which is 32. And then entire 5 pages is bias, presumptive. The clarificatory question which my Lord put. Presumptive bias, automatic bias. And he cites this one para. There is a manifest error by the governor himself because the para cited does not touch on bias. It says apparent bias, which means demonstrated bias. Somewhere, he's attending the meeting. Well, demonstration is not difficult. I attend the meeting. Or I don't attend the meeting. I attend the meeting and I say, I will go out to the room and have a cup of coffee. You go and decide. Or I recuse. This meeting is separate. And otherwise the man is fully in every ministry dealing with the subject. It's possible. It happened partly in Antule's case, where I had the privilege of assisting the court. Antule, your lordship sees the file notice that directly is involved in so many things.
Yes.
So now in that case, apparent bias may be demonstrable bias. But if subconscious bias was the test alone, then your lordship doesn't have to go to manifest irrationality. And the moment you have a paradigm of a cabinet, a chief minister and a governor, it's automatic.
No, the two are contradictory. Subconscious, any concept of subconsciousness need not be manifest at all. This is the subconscious level.
Yeah, no, I'm saying subconscious will mean manifest is to query the reasons. Manifest is not query bias.
And
manifest is query irrationality in the order. I'm saying, if your lordship were to accept presumptive automatic bias, then the law would be that in any case and every case, without examining the reasons of the cabinet, for being wrong or right,
That is,
merely because it is the cabinet and merely because it is the CM, the governor must automatically deny or grant sanction as the case may be, on the ground that MP means that the moment there are three entities, governor, CM and cabinet, bias is established. I don't have to examine the order of the cabinet to see whether it is manifest irrational. I hope I'm clear. That's my proposition. So that's the proposition.
so you're saying that irrationality should be palpable and demonstrable.
In the order, no,
In the order, only then
Ah.
that would come about. Is,
Or
that is your
demonstrable means,
suggestion?
fellas, he must address it. I will let it put it lower. Let me put it lower for, my lord is absolutely right according to me in the way your lordship has formulated it. So that is number one. But let us take a worst case against me. I am now deliberately testing. First point is what your lordship has said. That's the perfect formulation for manifest irrationality. But now I'm taking a point against myself. Let me assume that the governor doesn't delve into the way your lordship has put it just now. He must show something that, look, I have read para 50 to 80 of this cabinet decision. They missed out that in para 69, this gentleman was actually handling the portfolio, or he gave an instruction, or he did sign the file. This is the error of the cabinet. And therefore, I believe prima facie there should be some inquiry. What the learned governor does is, he doesn't address, he doesn't go down that path at all. He says only, I'll read the order again,
Yes.
he says, because this is a cabinet, cabinet is deemed to be, I wish chief ministers would appoint cabinet the way the governor thinks they can. A lot of chief ministers would be very well wistful to be told that every member of the cabinet is appointed by them. Your lordship knows that, all of us know it. But let us for a minute assume the only reason given is cabinet is deemed to be part of Mr. Siddaramiah. Siddaramiah is the head, and the constitution says that the cabinet is represented through the chief minister. He's the first among equals. Therefore, presumptive bias, well, what your lordship put to me in a question form. Therefore, there is no question of my going and seeing where in para 89 they have messed up or given an irrational reason. I don't need to go there. Why? Because para 32 of MP Oil says so. But MP Oil never talks of bias. I'll read that. MP Oil goes into and says the cabinet is wrong for these reasons. And therefore, the governor must do it independently and decide it like this. This is the error of the approach. Para 2.3.4.
No, are you saying that the governor should not have disagreed with the cabinet?
Not at all. I will
So
never say
his
that.
disagreement should have been found in the order,
In his order,
reasons in the
in
order.
the governor's order.
Governor's order. That
Absolutely.
is your submission.
That is right. Now, I can never say that he can never disagree. That is an extreme proposition, and that will never be said.
So the disagreement should be found
And
by reasons recorded in writing in the
first
order.
part is just your lordship, full stop on the first sentence. Disagreement must be found in the order. That is enough, full stop.
All right. Yes.
Second part of my lord's formulation. If it is found in the order must demonstrate manifest irrationality in the cabinet with which he is disagreeing.
Why should it be found in the order only if the files contain reasons?
He has to, no, files will contain, he has to, not by, he has to give some process of reasoning by which he comes to that conclusion.
Yes.
The third part, if the second part is not correct, then the order will say, I grant sanction, go and find the reason in the file. Then what is your lordship going to do? Judicial review? What is the heightened judicial review? What is the meaning of manifest irrationality of MP? Your lordship will have then the Sphinx. Then the Sphinx comes in. Your lordship has to dig behind the Sphinx and find out something.
Yes.
Last one. MP police is not an authority for the proposition that there is any presumptive rule of apparent bias. I'm addressing the issue. The lordship's clarificatory question is more pointed, but in a sense, I've addressed it here, partly, without your
No, I'm just getting clarification what is running in my mind. So you should not.
I am very grateful. I am genuinely grateful.
I'm not disturbing your flow.
But I am
yes.
genuinely, I would not say it otherwise.
Yes.
I'm genuine because it helps us to clarify as we go along. Any query, it's most welcome, but it genuinely helps me to clarify because this is a matter where we are in the frontiers to some extent. Lordship should get the law right, apply to the facts secondly.
Because the submissions are so much, the horizons are so wide now. I need to take some
No,
clarification
with
somewhere.
great respect,
yes.
Malad. It's most welcome and I'm
Yes.
absolutely grateful. The proposition that there is any presumptive rule of apparent bias on the basis of which the governor must always independently consider the matter when an allegation relates. I'm denying that is so. The first sentence. Paragraph 2.3.4, page 5.
Yes, I am there.
The question of apparent bias did not arise in that case. Rather, that case concerned a question of likelihood of bias, also expressly rejected by the Supreme Court at So, subconscious bias is out. Your Worship, no, subconscious is not likelihood. Likelihood means I must show that there is some facts which will show bias against him. So that was the case. Even that was rejected. But still the matter went the other way. Why? Because of irrationality. That's what is developing now. The reliance on para 17 in the written submissions is misplaced and misleading. The MP Special Police Establishment case is not and should not be read as general authority for the proposition that in every case where there is an allegation against the Chief Minister, the governor can exercise discretion independently, even absent any irrationality in aid and advice given by the cabinet. The mere fact that the governor may, in certain very limited situations, differ from the aid and advice of the Council of Ministers does not imply that every such different view of the governor is to be automatically preferred. Just like every view of the cabinet need not be preferred. My lord is absolutely right in that query, but I'm not suggesting that. In fact, the ability of the governor to decide to differ, this is very important with that boldface. The ability of the governor to differ is itself necessarily linked to a showing of manifest irrationality of the advice received. And that makes sense, fellows. Your lordship has a proper governance up to the judicial system then. Somebody gives an advice, don't prosecute him. That is not final, fellows. It can be rotten, can be horrible. Somebody here gives an advice that I agree with that advice. He can be equally horrible, he can be good. And your lordship is the ultimate master, ultimate meaning in the judicial hierarchy. How does your lordship do your job, Malas, if these two people don't give anything and they say we just decide? And the test your lordship applies will always be of irrationality. Has to be, Malas. There is no basis to suggest in the present case, either reflected in the governor's input or otherwise, that the decision was in any way irrational. Forget your lordship reviewing, there is no such reason given by the governor. Even the written submissions on behalf of R2 do not canvass irrationality at all. They get stuck, fellows, by misreading 32, the other side, in the submission, and they just quote MP because the governor quoted it, not realizing that the governor never went on bias, fellows, in that case. Rather, the submission is entirely based on apparent bias, assuming it to be a presumptive rule that where there is an allegation against the Chief Minister or member of council, the council is automatically disentitled or disabled. This is exactly the query I think now, Malas, it fits in, which your lordship put to me. It's exactly that issue. The council is automatically disentitled. The word automatically is important for me, my lordship, underline automatically. Disentitled or disabled from divested from exercising his powers. These powers are instead vested as discretionary powers. The decision of the Supreme Court and MP does not mandate any such presumptive rule, nor ought such a blanket rule to apply where executive powers vested in the state by statute are transposed as discretionary powers of the governor merely because the allegations relate to a chief minister or member of council of ministers. The reference to the file put up to the governor and comparative charts, as well as notes dictated by the governor as part of a decision-making process, do not suggest any reasons as to why the advice was manifestly irrational. An optical juxtaposition of two versions in a comparative table cannot be equated with an application of mind. As your lordship said, I could have made 3 columns. Also, I could have made 4 columns. Why does the lordship prefer that column to this column, to this column, to this column? Let there be 5 paragraphs, 3 paragraphs, 2 paragraphs. Why that is preferred and this is not preferred, this is preferred, this is not preferred. I can't make a table and give a lordship. These are the various versions. The process of ratiocination required a link, a chain, or a clear nexus between these materials, the reasoning, if any, of the impugned order, and the conclusion there is. All this is conspicuous by its absence. The impugned order of the governor was passed in undue haste with a predetermined mind and exhibits a cherry picking. This word cherry picking is very important. I'll just show in a minute. But this is a case which demonstrates without doubt there is cherry picking. Without doubt. And very interesting. it shows cherry picking in the wrong and it shows cherry picking in the right. I'll just show that in a minute. Very interesting case. Where the present case was unduly and hastily fast-tracked, while several other applications for prior approval remained pending for long duration. My lord knows those 6 examples I gave. One year, Manoj. One example is 2 years. 2 years. 2 years. Interestingly,
Still
while your
pen-
lordship is hearing that matter,
Still pending?
no, while your lordship is hearing the matter, perhaps somebody's arguments have had some effect. One of those 2-year applications has been decided on 8th of August. And that is the cherry picking I'm going to show in a minute. After your lordships have heard most things just now. And it's very interesting. It's very instructive as what the governor could do, should not do, and did do. That is one of the complaint of which month in 21? 2021, which month? It's in 21. Decided in 24. Mine is taken up the same day and show cause is issued. Well, nobody is going to come and say this Article 14 arbitrary written on the file. Your lordship, read between the
Oh.
lines.
That was sanction or approval?
That was approval.
17A.
Your lordship would not even find a 17A pending for 17 months. Here we are 3 years. Give me the date of that application.
But in other cases, sanction was sought.
No, is it sanction or 17?
I don't want to be wrong.
Sanction was
I am told it is.
19 sanction.
Give me the date. I am instructed.
No, it can't be 17A, I guess.
But it should not be, is different from can't be. It is. It is.
17.
You sure?
Page 127. Do you want me to give you?
120, give it. 127, we have the order. Let's be factually correct. Give it. This is issued while your lordship is hearing the matter. So,
Not while hearing the matter, but it's the.
One minute.
You appear for the complainant, not
All
the
right.
governor.
No. What is this?
after the PM's reply, this particular document, just come to 127 minutes. After this, the chief minister, my client, replied. When did I reply? 3rd of August, I replied. 9th of August, this order comes. As directed, I am enclosing a copy of the decision of the competent authority for permission to conduct inquiry under 17A. So first point is 17A. I hope I am clear, Malas. It is 17A. Against Shishikala Jole, former government, etc., etc.
It is, permissions denied.
Yes. That part is not surprising, Malas, but that is different. This is denied. It is. Now, let's not get into details, but this is a supposed sting operation on camera for a person supposedly supplying eggs, etc. for midday meals of schools, recorded on candid camera, where the Honorable Governor takes 2.5 years to apply his mind, and after 2.5 years or 3 years, rejects it. In my case, for 20 years, not a single file dealt with by me, and he issues show cause on the same day. Well, this is not Article 14, it's shocking, is the word for it. But at the moment, I'll be coming to this thing. 17A is important, the question my lords asked. Give me the date when the application. I'll not give you the date. It's 2021 someday. 9/12/2021. And the decision is 9th August 2024, exactly 3 years. 4 months less. That's all right. You don't get into details. Well, the application is also in this bunch at page 693. In the writ petition, Annexure J, is this application which I talked about. December 2021 is when the application was made to prosecute or to get this 17A.
Yes.
This small digression, I'll spending half a minute on Article 14, as I've said so many times, the two most important articles, and even more than 21 is 14. And 14 had 3 phases. Give me a minute to digress. I know it's a digression, but it's very important to emphasize. Till when it came in, your lordship knows those so many decisions, Charanjit and R.K. Dalmia, we had basically the discrimination facet of 14. Classification, doctrine and discrimination, but classification mainly. In Royappa, which came 30 years after 74, 30 years after independence. Justice Bhagwati, for the first time, brought in the seeds of arbitrariness. Then malas those 70s and 80s, the same Justice Bhagwati malas developed it beyond malas compare in all the Ramanna Shettis and all the malas cases. I hope I'm clear, malas.
Yes, yes.
So you had a second facet of 14. Then malas, the third facet came in Maneka, developed later, or procedural due process. We still kept the figment of the fig leaf of denying that we have no substantive due process in our constitution, because the Lordship knows Venegal Rao had gone abroad.
Yes.
Frankfurter had said, do anything, but for God's sake, don't put this phrase due process. So, Article 21 had a due process clause, or the counterpart article. So, when Venegal Rao met Frankfurter, who was a very restrained, limited judicial review man, he said the bugbear of American jurisprudence is this crazy phrase, due process. Don't use it, do anything else you like. So, Venegal Rao came back and reported. So, they put this phrase, except in accordance with law from the Japanese constitution. They dropped due process. So we like to say that we had no due process, but Maneka brought in procedural due process, clearly. So that was phase number 3. Then finally now, in a trinity of judgments authored by Justice Nariman, there is full substantive, full-blooded substantive due process. Both Venegal Rao and Frankfurter must turn over in their grave. Because triple talaq, this adultery, then that Swiss ribbons, all of them recognize IBC under different. That substantive due process is a part. So your Lordship can see the degree of unjustness to strike down. Now, I am saying that if your Lordship were to apply even the old test of 14, now we have 4 facets of 14. This kind of conduct that you take 3 years minus 4 months for a 17A and then reject it for a candid camera, the complaint is there, Malas. It's a recording of what is done about midday meals. And on the same day for a person who for 23 years has not signed a file, not made a recommendation, not been anywhere, you issue a show cause. Then, Malas, you don't need Article 14 for that, you need common sense, is all that I'm saying. You don't need Article 14 to make out, Malas, clearly. Now, Malas, at 2.9. No, I'm sorry, 2.8 is very important. 2.8 your Lordship is marked cherry picking. Now your Lordship will come to 2.8a. Two facets are interesting and ironical in this regard. None of the diverse complainants seek any sanction, prior approval in respect of any of the multifarious public servants alleged to be involved in the present case, stretching from 98 to 21 over a period of 23 years. I'm sorry. My Lord has got it. I'm very sorry. 2.8a. The last sentence, please read. Petitioner CM is singled out for the affection of the complainants. 23 years, hundreds of officers, not a single one. Secondly, in stark contrast to the impugned order, which does not contain a word as to how, what, when, and in which manner. This is very interesting for us. The governor finds the petitioner even remotely culpable for the purpose of granting sanction or prior approval. The very same governor gives specific reasons in the order of 8th of August regarding lack of culpability while rejecting the proposal of prior approval in the case of Sashikala Jole. A case specifically stated in the pleadings pending before the governor for several months. Well, the sentence is not correctly drafted. It should be comma, maybe continues. The point is, Malas, I am not asking for reasons, inviting. I'm saying the order is bad because it has no reasons. But is it not relevant that your Lordship is hearing a matter? 8th August is hardly a month ago or whatever, Malas. Your Lordship gets an order which has reasons copiously saying, why don't grant sanction? Because this person is not prima facie complicit. Because this person is not prima facie found to be involved. And in my case, on the same day show cause, not a single reason. Then 2.9. The manner in which approval has been granted is contrary to the statutory scheme and judicial interpretation of 17A. The statutory restraint is on the investigating officer. It is thus the investigating officer to first form an opinion. Their inquiry, this point is important, Malas, in the nuance of the interpretation. I'm coming to that later. Thus, for the investigating officer to first form an opinion, don't prevent him from doing that by this lateral entry. that inquiry or investigation is warranted and then seek approval or inquire investigation. The statute does not contemplate the said approval being sought by a third party, namely the complainant. The respondent wrongly contends that the test to be applied at the stage of 17 capital A is only whether the materials disclose the commission of a cognizable offense. The legislative history behind the introduction of 17A does not support such a contention, as is demonstrated later, even assuming that 17A is different from the standard of sanction. I'm assuming it, my lord has got that para. That does not mean that it is a Lalita Kumari standard. Lordship may add in hand here, third point. Even Lalita Kumari is not met on the facts. That's a third level argument, fellows. Because the same reason, doesn't tell you how I'm involved, when I'm involved, what did I do, recommendation, signing, event, decision, minister, portfolio, nothing. Even if the Lalita Kumari test is applied, in the facts of this case, it is clear on record that do not disclose the commission. The complaint request for prior approval does not specifically advert to any recommendation made, decision taken, or even any action. This is the single most important point in this case in my respectful submission. It's obvious from the reading of the order. The complaint request for prior approval sanction proceeds on a series of surmises and conjectures, casting doubt on official actions taken in the ordinary course by different officials at different times under different administrations. They also proceed to disregard several registered deeds and instruments which ought by the nation not to be doubted. It is clear that the petitioner himself had no role to play in the decisions or even deliberations. I've added at the end a list of dates for lordships, which I'll be coming to. It's very, very important on the facts. All this prejudice was created. Oh, there's a writ suppressed from you. The order in one case is this, in your case is this. It was never denotified. It was never factually wrong. Documents of registered deeds are there. They argued all this. I'm only rebutting. They argued the facts copiously. The poor cabinet has gone into it. My writ petitioner has got the documents. Still they argued those facts. So I put a list of dates at the end, Malas. Only for prejudice. Only to prejudice your lordships. That look, all these years, there is no acquisition. The acquisition is valid. The acquisition could not have been given back. 48A is wrongly done. Notification is wrong. Everything is wrong. Document said otherwise. Now, this 50-50 rule. It is clear that the petitioner himself had no role to play, or even deliberations leading to the decisions in the case of denotification, registration of deeds, decision by Muda with regard to 50-50 rule being applied, and allotment of compensatory sites to wife of the petitioner. Otherwise, Malas, had I got a role to play, I would certainly not have taken at least a decade to get this done. And had I a role to play, some of the most operative decisions would not have been taken when I was in the opposition. Some of the major ones. In fact, the Muda decision was taken in 2020 and implemented in 21-22 at a time when the petitioner was in opposition and not even a part of the government. And Malas, this is given to 19 or 20 or whatever number of other people also. It's a general policy decision.
But
Nothing to do with me.
But your son was a part of the board there in
I'll be
Muda.
showing that board. That's part of my list.
By being an MLA.
MLA. He's ex officio.
Ex officio
Ex officio.
member of the decision-making body on that particular day. Your son
Which-
was a part of it.
Which, Malas, is a ex officio requirement A. I did not make him B. The decision is across the board for so many people.
No, true. It's across the board. But
And I'll be dealing with that.
2 meetings.
That's not the
Both
point.
those,
And Malas, he is fortunately not named as
two
an
meetings,
accused.
one in 2020 and one in 2021.
Yes. And Malas, they have not made him an accused. They have not short
So
sanctioned.
they are not.
Malas, let us come to the next point. Shamsher Singh is important. Don't brush it aside as the respondents have done. They've completely brushed aside. This remains the bedrock for the last 60 years. 7 judges. Bedrock on constitutional law. President, governor, both. There's a typo there, 1974, not IG 74. Typo there.
Yes, sir.
The president as well as the governor is the constitutional or formal head. The president as well as the governor exercises his powers and functions conferred on him by or under the constitution on the aid and advice of his council of ministers, save in spheres where the governor is required by or under the constitution to exercise his function is discretion. Wherever the constitution requires the satisfaction of the president or the governor for the exercise by the president or the governor of any power or function, the satisfaction required by the constitution is not the personal satisfaction of the president or governor, but the satisfaction of the president or governor in the constitutional sense in the cabinet system of government. That is, satisfaction of his council of ministers on whose aid and advice the president of the governor generally exercises all his powers and duties. And Malas, that old saying, the elected people have a fundamental right, a duty, I would say, to do good. But they also have a right, not a fundamental right, to do bad and wrong. But it is their right to do wrong. It is my right to do wrong, and this population will set me right. It is not the governor's right to set me right, or the president's, is what Shamsher Singh's soul and spirit is. That's the meaning of elected democracy, or in a parliamentary system. It may not be in a presidential system the same way. Then, Malas, 54. The provisions of the Constitution expressly require the governor to exercise his powers are contained in articles to illustrate. Now, Malas, one article is given on the third line. Come to the boldface. The other articles which speak of the discretion, there are typos here. Typos have not been seen. Paras, what is that section here? S2 and 18.3 of the 6th schedule. Then articles so and so. The discretion conferred on the governor means that at the constitutional head or formal head, the part. This is one of the Northeast. Those powers, your lordship has special powers there, Malas. Then Malas 55.
Yes.
This is the failure of constitutional machinery. In the context, Article 163, I don't know why, Malas, only the articles are wrongly typed. Everything else is correctly typed. The number is 163.
Article 163.
Somebody is
Malas,
going with the uppercase and the lowercase is this
That's
problem.
not correctly typed. That's all.
It's 163 actually.
Yes.
Multiple, all of them are like.
163.2 it should be.
In article, in this context, 163.2 is explicable on the decision of the governor in his discretion shall be final and the validity shall not be called in question. Next, 2 lines later. In all other matters where the governor acts in his discretion, he will act in harmony with his council of ministers. The Constitution does not aim at providing a parallel administration in the state by allowing the governor to go against the advice of the council of ministers. In such matters where the governor is to exercise his discretion, I'm reading para 56, he must discharge his duties to the best of his judgment. The governor is required to pursue such courses which are not detrimental to the state. For the foregoing reasons, we hold that president or governor acts in the aid and advice of the council of ministers, with the prime minister at the head in the case of the union, chief minister at the head in the case of the state, in all matters which vest in the executive, whether those functions are executive or legislative in character. Neither the president nor governor is to exercise executive functions personally. I try and summarize some things in page 12. Next page. In relation, I put them point formulas. In relation to functions that are vested in the executive, the governor shall act at the aid and advice of the council with the chief minister at his head. The governor shall not exercise executive functions personally. 48 and 57 paras. Where the Constitution provides that the governor shall act in his discretion, here the articles are correctly put, Malas. Even in these matters, the governor shall act in harmony with his council of ministers. These are, Malas, nuances which we tend to forget. It is not, Malas, very interesting nuance. This Shamsher Singh, 74, Malas, is saying that even where he has a separate power, he must act in harmony with me in that. Look at the whole delicate balance. You can't say automatically I receive the cabinet decision because the chief minister is involved, I'll defer. Thus, there is a constitutional restriction on the discretion which is not to be exercised as a personal function or as a function conferred on him, eo nomine. In very limited scenarios, such as under 356 is a classic case, fellows, and 200, the governor may act in his own discretion even against the advice of his council. In such cases, the governor is to exercise his duty to the best of his judgment. That's para 55 and 56. Now, the most important, Justice Krishna. Now, why it is misrepresented, Justice Krishna is right. Not a word in the majority. He's concurring. Not a word in the majority dilutes or overrules or goes against him. Then why should Lordship not read Krishna? Justice Krishna just brush aside, he's a concurrence. But concurrence is not a dissent, Malas. Please don't read the concurrence as a dissent. You can point out that this concurrence is violated by this part of the majority. That I can understand. Not a word. Ignore it because of the concurrence. And Justice Krishna spoke for himself, Justice Bhagwati. If the inner voice of the founding fathers may be any guide, para 113, it is proved beyond reasonable doubt that the president and for sure the governor enjoys nothing more and nothing less than the status of a constitutional head in a cabinet type government, a few exceptions and marginal reservations apart. Mark this word, a few exceptions and marginal reservations apart. Actually,
Yes,
the governor has more powers than the president.
yes.
People tend to forget that. President is even more limited. Governor has little extra powers. For example, president has no 356 powers.
Yes.
Our Pakistan president has a 356, which he has liberally excised 2 or 3 times. He dismisses the national government with us. We decided against having that in the president. We had it only for the governor. Nobody can dismiss the central government here with us. Of course, there is some qualitative difference between the position of the president and governor. The former, under 74, has no discretionary powers. The latter too has none, save in tiny strips. Look at the approach. Tiny strips covered by, please forgive me for the typos, but it's 163, somehow coming at 1C3. And all the others are given. These discretionary powers exist only where expressly spelled out, and even these are not left to the sweet will of the governor, but are remote controlled by the union ministry. This is very important. Well, the governor, when he acts independently, so-called, is independent of the state government. But the union government is answerable to parliament with a whole set of provisions. Lord should know the 356 proclamation expires if parliament doesn't approve it within a certain time period. Again, a minimal area centering around reports to be dispatched may not, that's for 356, not 35C, may not in the nature be amenable to ministerial advice. Now come to page 14. Even where express conferment of power of functions is written into the article, such business has to be disposed of decisively by the ministry, answerable to the legislature, and through it vicariously to the people, thus vindicating our democracy instead of surrendering it to a single summit soul. These are the simplest language which Justice Krishna may have used. He's erring on the side of oversimplicity. But a single summit soul has a rhythmic alliteration, which exactly describes the reason to avoid the governor or the president. That single summit soul is the governor or the president, whose deification is incompatible with the basics of our political architecture. Lest national elections become but Dead Sea fruits, legislative organs become labels full of sound and fury, signifying nothing, and the Council of Ministers put in a quandary responsibility to the House of the People and submission to the personal decision of the head of state. A parliamentary-style republic like ours could not have conceptualized its self-liquidation by this process. On the contrary, democratic, etc. Sometimes I think that how times have changed. Well, it's today, even if you have a person like Krishna Iyer, he could never go onto the bench. Because we are into narrow confines. You can't be in public life, you can't be in law, you can't be on the bench.
No, he was in public life.
Actively, a minister.
Yes.
Forget active life.
As a
minister,
for 3 years.
and then became a judge.
Then became a judge of the Kerala.
Which is why he never made it to the top, but he was a senior judge. But nobody could raise a finger. That is the spirit of the times. Nobody could even suggest this. And one of my most cherished memories is that as a young student, I wrote an article in the Illustrated Weekly.
Oh, the then Illustrated
Weekly,
yes.
a very famous magazine
Yes,
about election law. I had been in some elections seeing something. Elections, law and reality. So I was juxtaposing. But Justice Krishna was retired by then in the 80s.
Yes.
Wrote a very nice note handwritten to me, saying I read the article. He knew my father was, so he took the trouble of writing a note to me personally. And he read the whole thing and he wrote something which overwhelming to have it. Then 152. Long arguments on the terminological niceties of the various provisions, divorced from the essentials of parliamentary perspective, will land us in Himalayan constitutional blunders. Similarly, expressions like is satisfied, opinion, as he thinks fit, if it appears to, have to be interpreted by superimposing the invisible but very real presence of the ministry over the head of state. Opinion of, in the view of, appears to be. We declare the law of this round. This is 154, which was brushed aside by saying this is only a concurrence. So I've quoted it. Please tell me which part of the majority dilutes or violates 154. or tell the Lordship it is the over breadth. Unless you do that, you can't just brush it aside. Supreme Court, 7 judges. In that way, Bomai could be, Bomai Lordship had 9 judges with 4 or 5 judgments. Most for all concurrences.
Yes, concurring.
Your Lordship doesn't brush aside just like that. Very Karnataka flavor, Bomai. The most important change in 356 has been that Mr. Hegde, by the time Bomai was delivered, he was the petitioner originally.
Yes, yes.
By the time Bomai was delivered, the government had changed 2-3 times.
Yes.
He never got the fruits of his victory. Subsequent to 2000, there are only 7, 8, 10 356s. Because your Lordship's judicial review was not only the same as Bomai, very swift. Very swift.
So many things.
No, your Lordship's judicial review was very swift. I've had the privilege of assisting the court in Uttarakhand, Karnataka,
Yes.
Maharashtra. Your Lordship decided within a few weeks, this way or that way. So 356 did not become a very valuable tool to dismiss government because your Lordship said reinstall him back. In all these cases, Uttarakhand, Karnataka, have the elections or have a floor test and all that. Bomai took 3-4 years before the man lost several governments. So he got a Pyrrhic victory.
Yes, it
We
was a Pyrrhic victory.
It was a Pyrrhic victory, although he established law forever. We declare the law of this branch of our constitution to be that the president and governor, custodians of all executive and other powers under various articles shall, by virtue of these provisions, exercise their formal constitutional powers only upon in accordance with the advice of their ministers, save in a few well-known exceptional situations. Without being dogmatic or exhaustive. This was read to your Lordship, so I'm reading it, Wallace.
Yes.
Please see the totality. Is it a fair interpretation? To say that this means non-exhaustive, means each case by case your Lordship will keep adding to the governor's powers. That's not fair, Wallace. It's against the constitutional scheme. Without being dogmatic or exhaustive, these situations relate to the choice of the Prime Minister, restricted through this choice by the paramount consideration it should come. But this word exhaustive here means something totally different. They are saying we are obviously not itemizing everything. It is not a license or an invitation for my lords to keep on having adventurous additions, which is what they are suggesting. The dismissal of a government which has lost its majority in the House but refuses to quit. The dissolution of the House for an appeal to the country is necessitous. Although this area, the head of state should avoid getting involved in politics, must be advised by the Prime Minister, who will eventually take the responsibility. We do not examine in detail the constitutional proprieties in these predicaments except to utter the caution that even here the action must be compelled by the peril to democracy, and the appeal to the House or to the country must become blatantly obligatory. Now, my conclusion, Malas, on this part. As such, the declaration of law in 154, which forms part of a concurring judgment, must be seen in proper context. By no stretch of imagination can the judgment in Shamsher be seen as providing an open-ended, non-executive list of subjects. That's the crucial point, where the Honorable Governor may exercise, etc. But rather the court expressly said it is confined to a few well-known exceptional situations, which your Lordship may in a very calibrated, controlled manner, restrained manner, sometimes allow. Then, the last judgment is where happened recently, the Maharashtra thing. This is not about this or 10th schedule, but just 2 minutes. Very after.
Continue at 2:30.
I'll continue.
Yes.
2:30,
2:30. Yes.
Obliged. Deeply obliged.
Yes.
And challenge.
ಇದು ಮೂರು
Sorry, I apologize for that.